This channel is all about employment tribunals, everything you might need to know and how to represent yourself. Today's episode is about, have I got a case at all? The things you need to think about and thinking about what sort of motivations you might have for bringing a case at all. So let's get to it. So before even thinking about an employment tribunal, the most important thing to decide is, do I have a case? So the questions you need to ask yourself begin with things like, why am I doing this? If you're doing it for something like money, really think about whether you have a case at all. The outcome of a tribunal does not always result in money if you're successful. It will result in things like the employer being forced to give you your job back, if that's what you want, or it might involve a small amount of compensation that might not even cover the time it's taking you to prepare. So if your motivation is money and money alone, really think about whether you've got a big enough case for it to be worth all of that time and hassle. If your motivation is justice, then just go for it. The most important thing about employment tribunals is that justice is done. It's that employers are held to account. It's that they can't just carry on behaving the way they are and get away with it, because people will hold them to account. So, do you have a case? This is where you need to think about the evidence that you might have, witnesses that you might have, and anything else that you've got which is an absolute no-brainer for a judge. So, do you have witnesses? Witnesses are a really tricky part of an employment tribunal, mainly because they are likely to be somebody who is employed by the person that you are taking to court. So the chances of them standing against their current employer to represent you is quite low. So you might think in your mind, oh, it's okay, Sally saw that. Sally will definitely back me up. Oh, and I know that Julie saw that bit too, and there were 3 people in the room when that happened. That's all well and good, but will those people be happy to stand up in court, look their employer in the eye, and tell your version of events? I learned the hard way that the answer to that question is no. And the people that you think are your friends at work don't always stay your friends after you've gone. You might think that you'll be friends forever, and it always feels like that. And there'll be people that you've worked with for 10 years, and they feel like your work family, and you always say, well, if I go, you'll go, and all that. But the truth of the matter is, once you've gone, they all just kind of get used to life without you, and they will forget you, and your work friends are not your life friends. They're just your work colleagues. So what incentive is there for them to go against the person who pays them their monthly salary to help you? And it's probably horrible to hear, but the fact of the matter is you're very unlikely to get a current employee at your old place of work to represent you in a tribunal. So if those are the only witnesses that you think you've got, your case might not be as strong as you think it is. So you need to think about other evidence that you've got. Witnesses don't have to be people who were there and saw the thing happen or were aware of the stuff that was happening at work. Witnesses can actually be members of your actual family or your friends who were there being told about it in the outside world, who had seen how it was affecting you, who might be able to back up that certain things happen on certain dates because on that date you ran straight home and told them about it, or you phoned them up and had a chat about it on that day. And you know, some of the evidence might be the telephone call on your bill that shows you phoned them on that day. It's thinking outside the box a little bit when it comes to witnesses. Some other evidence that might have been useful is, people will always say this, have you kept a diary? If not, start now, backtrack it, write everything down, because that will be really useful, especially if you've got things that might back up those dates. Like earlier I mentioned about a telephone call might back that date up. Having evidence which is just your chronology of events is hugely important. So how do I know if I've got a case or not? Did your employer break the law? There are a lot of laws. There are equality laws, there are employment laws, and then there are just straight criminal laws. Assess which of those laws they broke. If you think that you were, for example, unfairly dismissed, what was unfair about your dismissal? If you just plain disagree, that might actually not be unfair. What makes it unfair is a fundamental breach of fair process. So, did you have a disciplinary meeting? If you did, were you allowed to bring a witness? If the answer to that question is no, then it was an unfair process, because you are legally allowed to have a witness with you. That witness can only be a colleague or a trade union representative unless they decide to offer you someone else. But if they didn't offer you anybody or they refused, that's unfair. So there's an example for you. You need to prove that they fundamentally broke the law. So when you're assessing whether your case has got value and whether you've got a case at all, these are the key things. Do I have witnesses? Do I have evidence? And did they actually break the law? Those are the 3 things to think about. I hope this has helped, and I'll see you in the next video.